My name is Jeremy Shepard, and I'm the president of the Debtors Bar of West Michigan. This is our 11th annual seminar to take place on Martin Luther King Day. As many of you may recall, our organization has provided various awards on behalf of our members over the years. In recent years, we've started recognizing members of our Debtors Bar for contributions they have provided. Prior recipients of our Distinguished Colleague Award were Carol Chase, David Anderson, Michael McPhillips, and Martin Rogalski. With Carol Chase's passing, the Debtors Bar decided to rebrand the award, the Carol Chase Distinguished Colleague Award, in honor of her past service to our bar. This year's recipient was sent his award by mail, which looks a lot like this. Since we couldn't conduct the seminar in person, this year's recipient has been practicing for over 50 years and has made an impact on our bar through representation of debtors and trustees. This year's Carol Chase Distinguished Colleague Award goes to Paul Davidoff. Paul has some brief words to say, and we will get started with our speakers. Please be sure to congratulate Paul on this well-deserved recognition.
That better? Thank you, Jeremy. I hope you can hear me now. This is a great honor, and I very much appreciate the Debtor Bar of West Michigan giving me an honor in memory of Carol Chase, who was a wonderful person and an extremely capable debtors attorney. I'd like to say a few words about one of my famous cases. I had very few famous cases because I lost almost all of them, but this one is famous because I somehow won it. One day I was sitting in the office waiting for something to happen, and the phone rang and they buzzed me and said, "I can't understand this person. You have to talk to her." I said, "Paul Davidoff." And she said, "Wah, ah, ah." She's crying, she's sobbing. I said, "What's wrong now?" She said, "I can't eat, I can't sleep. My husband's threatening to divorce us. We got lawsuits, garnishments, the kids are a mess. I need help." And I said, "Are you working?" She said, "Yes." "Is your husband working?" "Yes." "All right, why don't you come on in? Let's see if we can't put together a Chapter 13 plan and stop all of this noise." They came in, and sure enough, they had extra money left over at the end of the month. We put together a 100% Chapter 13 plan, 3.5 years by payroll deduction. First meeting went fine. The plan was confirmed. Everything's great. And about a week later, I got buzzed again. "You won't believe who this is." I said, "Oh no, what's going on?" "Paul Davidoff." "Ah!" I could tell right away from the crying who it was. I knew who this guy was. "What's the matter now?" "Consumers Power Company is here to shut off my power." I said, "Oh, that's interesting. We listed them in the Chapter 13 case. Let me talk to the guy." And I put him on the phone. I said, "What are you doing there?" And he said, "Well, I was told by the company to come out here to shut off the power because they're behind in their electric bills, and that's why I have to shut off the power." I said, "Well, that's interesting because they're in Chapter 13. You're violating the automatic stay. You have no business being there." "Okay, I'm sorry. I didn't know that." And then I heard the door close behind him as he left. I was just about to hang up when all of a sudden on the phone comes General Patton. "Didn't you tell me that when I filed Chapter 13, there would be an automatic stay?" I said, "Yeah, I did." "Didn't you tell me that if anybody called me or tried to bug me or harass me, they would be in violation of the automatic stay?" I said, "Yes." "Then I want to file a motion against Consumer Power Company to hold them in contempt of court for violating the automatic stay." In those days, I was much younger and not as well-versed as I am today. So I filed a motion against Consumers Power Company to hold them in contempt of court. On the day of the hearing, which was held in the federal building in Kalamazoo, in the big federal district court, the Honorable David E. Nims Jr. was the judge. And for those of you who never had a chance to meet or practice before Judge Nims, I feel very sorry for you because I consider him the finest judge I've ever appeared before at any level, including 2 cases I handled in the Sixth Circuit Court of Appeals, which I lost, by the way. He was a phenomenal judge. He was patient, he was kind, he was intelligent. He listened. He never raked an attorney over the coals in front of the client. But he had one peculiarity that I'll never forget. He was the most punctual judge I've ever met. At
I think it's most properly
1:29, he would pull out his pocket watch, and when the second hand got to 12 and exactly 1:30, he would open the door and walk into the courtroom. He was the most punctual judge I've ever seen. As it turns out, this case was scheduled for the second case at 1:30. I saw an attorney from Jackson and 3 women come in to the courtroom for Consumers Power Company, and my client's not there. And I'm telling you, I know that this is going to be a bad scene. If she doesn't show up, we could be sanctioned with attorney fees and costs, and God only knows. At about 1:28 and a half, I hear click, click, click around the corner coming toward the courtroom. And here's my client, dressed like she's going to Easter Sunday services with a beautiful dress, high-heeled shoes. Her hair was combed nicely. She had makeup on, and she comes up to me nose to nose. "Are you ready?" Well, now I'm nervous because I had no choice. I better be ready. So we went in the courtroom. The judge called the case, and I made an opening statement explaining what had happened. I said, "All right, Mr. Davidoff, call your first witness." And I called my client, who got on the stand, and I didn't know if she was going to break down and start sobbing like she had every other time I talked to her, or whether she was going to be able to present this. And frankly, in the 50-plus years I practiced law, I never had a witness do a better job on the stand than she did. She laid it all out beautifully. She said, "When we met with Mr. Davidoff, he told us that there would be an automatic stay when we filed the case that would stop letters, phone calls, lawsuits. They can't call us, write us, or bug us. If they do, they're in contempt of court." And the judge said, "Not only did Mr. Davidoff tell you that there's an automatic stay, the Congress of the United States, in adopting the bankruptcy code, established the automatic stay to protect debtors in all bankruptcy cases." She finished telling the story. The judge turned to the other attorney and said, "You've heard the debtor's testimony. What's your response?" He stood up with his hands behind his back like he had a hat in his hand, the tail between his legs like a little dog, and said, "Well, Your Honor, we apologize. Whenever we get notice of a bankruptcy case, we put it into the computer. And on the day in question, our computer system was down. So we had no way of knowing that these debtors had filed bankruptcy. We relied on the card file, which did not have bankruptcy on it. Then we sent out the representative to turn off the power. We certainly did not intend to deliberately violate the automatic stay, and we apologize to the debtors." And the judge said, "That's not good enough." All of a sudden, I'm on the edge of my seat. This is starting to look pretty good. I really didn't expect that this was going to happen. He said, "I find Consumers Power Company in contempt of bankruptcy court for violating the automatic stay." In what was probably 5 seconds, it seemed like 10 minutes, all of a sudden I'm going through 500, 1,000, 5,000, 10,000. I think it was up to $100,000 of damages that were going to be awarded to my client for this violation of stay. And then the judge says, "But," and it was like somebody stuck a Bowie knife in my back. I couldn't believe it. And then they twisted it. "Don't do this to me, Judge, please." "I understand," he said, "that in this relatively new age of computers that these systems can go down. And as a result of that, although Consumers Power Company is in contempt of court, I'm not going to fine you. But if this ever happens again, I guarantee you, you will be fined." That was the end of the hearing. My client got off the stand, went outside the courtroom. I figured I might as well go out and commiserate with her because I figured she would tear my head off. We didn't get any money out of this. What good was it? But instead, I walked out and she had a big smile on her face and shook my hand and said, "Thank you so much. You did a great job. I have renewed faith in the legal system. I didn't know whether this automatic stay really existed or not. I just wanted to see whether the court would enforce the automatic stay. I didn't want any damages, and I found out that yes, debtors can be protected by the automatic stay. It exists, and the court's willing to enforce it. Thank you very much. She left, and now, as Paul Harvey used to say, now I'm going to tell you the rest of the story. The debtors had a payroll deduction set up. They never missed a payment. I never heard from them again. 3.5 years later, they completed their plan. And the only other time I saw them was when they had to go to court for the discharge hearing. In the old days, instead of getting a discharge in the mail, debtors had to go to court and listen to a speech that the judge gave them about what bankruptcy meant, what a discharge meant, and encourage them to go on with their lives and be successful. One of the reasons I'm so impressed by Judge Nims was every time he held a discharge hearing, he told the story of his own father, who is a businessman in a small town where they live. And one year, the economy went south. He couldn't continue the business, and his own father had to file bankruptcy. But many years later, when he died, the entire town came out as a tribute to him because he was one of the pillars of the community. He was beloved by everybody in that town. And he used that example to let people know that even if you file bankruptcy, it's a bump in the road. It's not the end of anything. It's sort of a way station along the road of your life. Now pick yourselves up, go out, and make a success of yourself from here on in. So I'd like to, again, thank the Debtors Bar of West Michigan for this wonderful honor. I'm going to put this plaque up on behind me on my shelf back here, so anybody who walks in can read it and see it. And I wish all of you the very best. And remember Martin Luther King Jr., one of the great Americans that we've ever had. Thank you.
Thank you, Paul. Congratulations. I think we're now ready to move into the educational materials. That brings up our vesting panel. Judge Gregg, Elizabeth Clark.
Good afternoon, everyone. This is the program entitled Vesting. We apologize for the lack of creativity in the title, but hopefully when we conclude today's presentation, you will understand why a simple title of vesting is appropriate. The District Court for the Western District of Michigan has termed what we are going to discuss today anything but a model of clarity. And as we proceed with the program, I want you to keep something in mind, and that is that there is not necessarily a right answer. There are only issues to consider. And with that said, let me first introduce Ryan Beech, who has graciously put together not only today's program, but participated in the formulation of the annual conference. And Ryan is an attorney practicing in Grand Rapids, primarily in the consumer realm. Joining Ryan on the panel is Elizabeth Clark, known to many, if not all of you, the staff attorney for the Chapter 13 trustee in the Western District of Michigan, Brett Rogers. Our format today is designed to be somewhat semi-interactive. And what I mean by that is that we do have the Zoom chat feature that many of you are no doubt familiar with at this point. And we'd ask you to use that throughout the course of the presentation in order to submit any questions that you might have. We'll also leave some time at the end. I think we've reserved about 10 minutes for questions at the end. But if you have a question on a matter that we're discussing, please send a chat. I will try to field and perhaps filter those questions. I may elect to leave some of those for the end, but we will do our best to address the questions that you do have. So with that said, what exactly is vesting? and why are we talking about it today? The term vest, or a derivative of vest, appears no less than 8 times in the Bankruptcy Code. And for purposes of our discussion today, we're going to direct you to section 1327B. Chapter 11 contains an analog to 1327B, and that is found in section 1141B. It has nearly, if not identical, language to 1327B. And identical language is found in chapter 12 in section 1227B. Notwithstanding the fact that it appears no less than 8 times in the Bankruptcy Code, the term vest is not defined in section 101 or anywhere else in the Bankruptcy Code. It is nonetheless a cornerstone of the model plan in the Western District of Michigan and in every other district in the country, for that matter. It has far-reaching consequences, and it requires a great deal of foresight by debtors' counsel when discussing and implementing a Chapter 13 plan. The Supreme Court has instructed us that when a term is undefined by the statute, we are to look to legal dictionaries as well as general usage dictionaries. But before we do so, and straying away from the definitions, which we'll get to shortly, what's your gut tell you that vesting means, Ryan?
Well, like I said earlier, I mean, I think it's very murky. We're not going to be able to give a clear answer here. But after doing a lot of reading and looking into the issue, I guess I would say my gut says that vesting means full transfer of ownership. Well, that being said, I don't think I'll always be arguing that that's what it means. Certainly, that always doesn't work out for the debtor. So if I could amend my answer to say it's whatever my client needs it to mean.
And that's probably the appropriate answer, and one that is strategic. Beth, you're confronted with the issue of vesting in every plan that you review. What do you think vesting means? Keeping the actual definitions to be discussed in a moment.
I've always subscribed to the narrow review in terms of vesting, and the view that I think we would find more in the cases that are reminiscent and adopting either the estate preservation approach or even the estate transformation approach. It essentially, at the minimum amount, you have possession. I do think that it amounts to more than possession, but not your full-fledged disposition and use, essentially relating to divesting yourself of title. I don't think that it extends to that degree. However, I do believe that it amounts to more than essentially just mere possession. And that's how I construe vesting as it's been afforded even under 1327.
Okay, I'll share with you that initially when we embarked on preparation for this program, I thought vesting needed to mean perhaps the vesting of title and conferred an ownership right. I'm now less certain after having reviewed the cases and the various approaches, but one thing to keep in mind is that we know that possession appears elsewhere, at least in Chapter 13, in that the debtor will always retain possession. And so it must mean something, or arguably it means something more than possession, but perhaps a little bit less than full ownership. Black's Law Dictionary, if we can move to slide 2, if we have that available, defines vest as conferring a right of legal ownership, conferring legal authority, rights, or power, the designation of endowment of power, the designation of authority, or rights. Similarly, the American Heritage College of Dictionary defines it as to place authority, property, or rights, for example, in the control of a person or group, to invest or endow with something such as a power or a right. What vesting means in this circuit is open to interpretation. The Sixth Circuit Court of Appeals has not yet considered the issue, and therefore you'll see a great deal of divergence in the definition of vesting as it appears in Chapter 13 from the courts within this circuit as well as on a national level. As I mentioned earlier, the Western District of Michigan has considered what vesting means, and the case is In re Calenda. And it's a case from 1997. The site is 212 BR 851. We're going to discuss that shortly, but I'll remind you that the decisions from the district court are not binding, although for purposes of today in your practice, I would look at them as highly persuasive. Before we begin to discuss some of the cases, as well as a hypothetical that Ryan and Beth developed, it might be helpful if we ran through and discussed some of the primary statutory authority that you will be confronted with when considering an issue of vesting. So let's start at the root of it, which is section 1327. What's 1327 say, Ryan?
Thank you, Judge. Yeah, there's three sections to the statute. A states that provisions of a confirmed plan bind the debtor and each creditor, whether or not the claim of such creditor is provided for the plan, and whether or not such creditor has objected to, has accepted, or rejected the plan. But the second one is 1327B, which will probably be the primary focus today, as the judge indicated earlier. That states that except as otherwise provided in the plan or order confirming the plan, the confirmation of plan vests all of the property of the estate in the debtor. So here's where we're getting into the meat of vesting, and we're saying that the statutory presumption is that the property is going to vest in the debtor unless something stated otherwise in one of two documents, the order confirming plan or the plan itself. The final section C states that except as otherwise provided in the plan or in the order confirming the plan, the property vesting in the debtor under subsection B of the section is free and clear of any claim or interest of any creditor provided for by the plan.
Okay, recently the Seventh Circuit Court of Appeals has tackled vesting for better or worse. And in what I'll call the vesting trilogy, the Seventh Circuit noted that section 1327B provides a presumption in that all property must vest in the debtor upon confirmation, leaving open a basis set forth by the debtor in the plan to state why certain property should not vest in the debtor and remain property of the estate. And the Seventh Circuit has been less than kind to the bankruptcy courts and the bankruptcy courts' adoption of the model plan. And in re Steens 918 F3D 554, decision from the Seventh Circuit in 2019, the Seventh Circuit essentially scolded the bankruptcy courts in the Northern District of Illinois for not making a debtor articulate a reason for property remaining in the estate. Apparently, after the Steens decision came out, the issue resurfaced, and the Seventh Circuit again reminded practitioners in the courts that the bankruptcy court must make specific case findings based on the evidence as to why property should remain in the estate and not vest in the debtor upon confirmation. I'm going to post these two decisions. I'll put them up there for you to review in your own time, keeping in mind that, again, vesting is subject to a great deal of disagreement. Section 1322 also enters into the fold. What's 1322 say, Ryan?
Well, focusing on section B, it states that the plan may provide for the vesting of property estate on confirmation of the plan or at a later time in the debtor or any other entity. So another section here, it's again giving some type of control to the debtor in proposing the plan on where it wants the property to go, remain in the estate perhaps, or vesting in itself.
Okay, and another section that ties in closely with vesting is section 1306. Why is 1306 important, Beth?
1306 becomes important because this is where the courts have really found the conflict, at least in particular when they're dealing with property that exists at the time of confirmation. And so when they're dealing with 1327 and looking at 1306, they usually find a conflict between the two. 1306A provides that property of the estate includes all the property that's specified in section 541, as well as property that the debtor acquires after the commencement of the case, but before the case is closed, dismissed, or converted. And so they've looked at especially those three conditions and have taken notice that confirmation is not tied into one of those three events, as well as any earnings from services performed by the debtor after the commencement of the case, again, but before the case is closed, dismissed, or converted. And then it does indicate that except as provided for in a confirmed plan or order confirming the plan, the debtor shall remain in possession of all property of the estate.
Beth, do you view 1327 and 1306 performing different functions?
I do. At least in particular, when it comes to, especially when it comes to assets that are required after confirmation of the case. I believe that there is definitely an inherent conflict between the two provisions when we're dealing with assets at the time of confirmation. But I do believe, and this will be expanded on later on, that they can still be reconciled and still given full force and effect when it comes to property at the time of confirmation. However, I take the view that after confirmation and relating to that property, 1327 is almost taken out of the equation. And where I see the most value when it comes to 1306 is relating to the post-confirmation assets. And as we'll see, even courts that have adopted essentially one of the three main approaches, even if they've adopted one of the three main approaches, they still realize the distinction between pre-confirmation assets and post-confirmation assets, leading us to believe that even if they adopt one of the three approaches from a pre-confirmation asset standpoint, they may still render that it becomes property of the estate from a post-confirmation standpoint under 1306.
And you mentioned confirmation. How
Yes.
does 1325 enter into, I suppose, your consideration of vesting?
So 1325C in particular states that after confirmation of a plan, that the court may order any entity from whom the debtor receives income to pay all or any part of such income to the trustee. And that provision, I think, is relevant for two main purposes. The first of which is that I do think it lends support for the approach that, again, even after confirmation, there are certain assets that come into the estate. Again, this specifies income, but it goes towards and further support of that interpretation that other assets should essentially be considered as part of the estate. And secondarily, that even if a court were to rule that a post-confirmation asset doesn't necessarily come into the estate, again, because they say that 1327 essentially takes out of the estate and essentially controls over 1306, it could be that maybe there's another ground for encapsulating it as part of the estate, because again, it may be construed as being disposable income.
Okay, those are the primarily statutory authority for vesting. However, it's important for a debtor's attorney to keep certain other provisions in mind. Notably, section 362 and the automatic stay, in that if the property vests in the debtor upon confirmation, then the asset is arguably, depending on the approach you adopt with respect to vesting, no longer protected by the automatic stay. Likewise, section 1303 provides that the debtor is bestowed with certain authority to sell, use, or lease property, but that property is limited to property of the estate, meaning that arguably, if the property vests in the debtor need not seek court authority in order to dispose of the asset. And finally, section 503B, meaning that if the property remains in the estate upon confirmation, that any subsequent occurrence involving that property may give rise to an administrative expense under section 503B. And I mentioned the Seventh Circuit trilogy. There is a second In re Steens case, and that is 942 F3D 834, a decision from the circuit in 19, where the circuit found that the city of Chicago was entitled to an administrative expense for vehicle fines that the debtor incurred where the vehicle was necessary to fulfill plan obligations and thus remained property of the estate. So these are some of the, I suppose, collateral sections of the bankruptcy code to keep in mind as you counsel your clients as to whether it is in their best interest to have all or some of the property vest in the debtor or remain property of the estate. Not surprisingly, section 1327, in conjunction for the most part with section 1306, has given rise to various approaches to vesting. And the courts are probably uniformly split among 3 or 4 different approaches. Ryan or Beth, you want to explain the first approach, which is, I think, a fairly simple one, the estate termination approach?
Yeah, I'll jump on it. Yeah, I think it is what it sounds like. The theory is that upon confirmation, the estate just ceases to exist. Everything vests in the debtor, and nothing refills the estate. It's just over.
Okay. How about the estate transformation approach, Beth?
Yes, and the estate transformation approach essentially holds that the property upon confirmation, it vests in the debtor upon confirmation, insofar as it does not conflict with fulfillment of the plan. So essentially what is being reserved in terms of the estate is any property that is necessary to carry out the plan. And so that this estate transformation has really been regarded as the middle ground approach, and has been criticized by a lot of courts for injecting a subjective analysis into the interplay between 1306 and 1327. It's probably going to be our most fact-intensive approach out of all of them.
And Ryan, how about the estate preservation approach?
Yeah, sure. This is the other side of the spectrum. So where estate termination was putting everything in the debtor's hands and being the most favorable to post-petition creditors, this is more of where everything stays in. Everything remains property of the estate. It's going to be protected by the automatic stay. They do say, a lot of courts, when they examine this approach, they do say that what vesting means in this scenario is that the debtors get some type of control over the property, but only to the extent that it's needed to execute the plan or successfully. So this one is going to be, again, the most protected of the debtor. Everything remains in the estate, subject to 362.
Okay, and finally, there has been a fourth approach that has emerged recently, and that's the modified estate termination approach. Beth, how does that differ from the estate transformation approach?
So essentially what it does is it indicates that it vests back to the debtor at confirmation, except property that the bankruptcy judge determines for good cause should stay in the estate. And so essentially what it does is, and this is what Matter of Steens by the Seventh Circuit, had announced, is that really they need to state with particularity why the asset is essential and should essentially stay in the estate. And that's the difference then essentially between that and the estate transformation approach. It's a little bit broader, I think, in terms of the language that it uses. Again, it uses the term good cause, then essentially being necessary to carry out the plan. But again, these two approaches are very fact intensive, so much more so than obviously what the estate termination approach is, or even the estate preservation approach.
I think it would be fair to say that the estate transformation approach and the modified estate termination approach are judicially created doctrines that may be subject to some scrutiny, given that there is nothing in Section 1327 itself that would lend to that interpretation. Nonetheless, it's certainly something to keep in mind given the uncertainty on what vesting actually means. In our district, the model plan provides that upon confirmation, all property of the estate shall remain property of the estate until discharge, unless marked below. Now, the Seventh Circuit would have some strong, no doubt disappointing words for the Western District of Michigan, given that the presumption seems to be that the property of the estate will remain vested in the estate unless otherwise indicated. But there is, I suppose, a release valve also in the Western District of Michigan model plan, and that's that there is a checkbox that allows the debtor to decide that property of the estate will vest in the debtor, except for, as Beth mentioned, in connection with 1306, future earnings of the debtor, as well as additional disposable income, and other real and personal property that is necessary to fund the plan. However, it is not left open-ended. The debtor's attorney needs to identify exactly what that property is. And I'll say that I have yet to see anyone attempt to identify property that would remain vested in the estate while other property will vest in the debtor upon confirmation. It's certainly an available option, but one that will take a great deal of discussion with the debtor as the client in order to decide what are the needs for satisfying obligations under the confirmed plan. The Western District of Michigan model plan also requires that in the event the debtor seeks to sell property of the estate, court approval be obtained under Section 363. Even if the property vests in the debtor on confirmation and the debtor elects to later sell that property, there's a threshold dollar amount, which is $2,500 for personal property or any real property. And in the event that the debtor does decide to dispose of that, court approval is nonetheless required. And so this is a way in which I think disclosure occurs and the trustees are kept apprised, as well as other creditors, of what the debtor is doing with assets that may be needed to satisfy claims of creditors later on, notably in the event that the Chapter 13 case converts to Chapter 7. The model plan for the Eastern District of Michigan in Section 5.0 provides that all property vests in the debtor upon confirmation and ceases to be property of the estate. The Seventh Circuit would be proud of the Eastern District of Michigan, and the plan provides further that the debtor shall remain in possession of all property unless provided below. The debtor is not to dispose of any property unless it's in the ordinary course of business without prior court approval. I'm going to take a guess, though, and in light of Section 1327B's language that unless it is provided in the plan or order confirming the plan, applying that language to the Eastern District's plan, I'm going to guess that a debtor could nonetheless identify property that would remain in the estate as part of the additional plan provisions. And so although it's formatted or worded a little bit differently, the same opportunity remains for a debtor to delineate between certain property or rebut the presumption in that the property should remain in the estate upon confirmation. When we discuss the hypothetical, we're going to primarily look to the language in the Western District of Michigan plan, but we're going to consider the various other approaches. And as I mentioned, Ryan and Beth came up with really an extremely thorough and well thought out hypothetical, which I'm going to briefly go over. and then we're going to perhaps address many of the issues that arise, keeping in mind that at this juncture, there's probably no right answer to any of it. Before we do so, we do have a question from Brian Rookert. And his question is this, and it's a challenging one. If the debtor vests property in another entity under section 1322, and if vesting is less than full ownership under section 1327, would the creditor in whom the property is vested have less than full ownership upon confirmation? In other words, would it be that vesting under section 1322 is different than under 1327? And Brian notes that there seems to be no indication that the word should be used differently under the two sections. Ryan, you have any thoughts on this question?
Yeah, if a debtor was looking to try to vest property in a creditor to get the title out of their name, I'm not sure that that works. I don't think that you can transfer title without acceptance. So I think the term is generally referred to as forced vesting. I've seen this used or attempted when properties were maybe underwater or essentially valueless, and debtors were trying to get the property out of their name so they could avoid things such as like municipality fines and other fees associated with not maintaining property. But I don't think it works.
Beth, you have any thoughts?
I would agree with Ryan, I think, on that statement, that I think such an attempt would have to still get court approval in that, and then possibly even, obviously motioned up and noticed out in the matrix. But yeah, I share in Ryan's take on that.
Yeah, I would tend to agree with both of you. This was a concept or a theory that was advanced by Judge Davidoff several years ago. And in fact, after he left the bench, I know he took up several cases in which he attempted to establish vesting in the unwilling secured creditor in order to, I suppose, relieve the debtor of any continuing obligations for taxes, insurance, and the like. While some courts did, in fact, accept the argument that Judge Davidoff was making, the majority declined. And I believe the Second Circuit said that vesting could not occur on an involuntary basis. And when I think of vesting, I think of Michigan real property law and how it's not sufficient to actually tender a deed for real estate. Rather, one must not only tender and have the transferee accept that deed in order for it to occur. I also note that, as Brian does in his question, there is no indication that the use of the word vest in section 1322 and the separate use of it in 1327B should be defined any differently. And in fact, the Supreme Court, as a canon of construction, has often stated that where a word is used in different parts of the statute, every effort should be given to give it the same meaning in both parts. But an excellent question. Moving on to the hypothetical, I'll briefly go over it. Rand and Min, they filed a joint Chapter 13 bankruptcy. They own a home as joint tenants with rights of survivorship. In their schedules, they stated the value of their home as being $300,000, subject to one mortgage with $20,000 as non-exempt equity. When they filed, the mortgage was current, and so they decided to keep the mortgage as a direct pay obligation. Rand and Min also own 2 vehicles, free and clear, with no encumbrances, and they also have a bank account. One of the vehicles is a Ford valued at $4,000 and is fully exempt. The other is a Volkswagen valued at $6,000 and has non-exempt equity of $2,000. Min has a retirement account which is fully exempted on Schedule C. The debtors, utilizing the model plan in the Western District of Michigan, checked the box stating that all property of the estate vests in the debtors. accept future earnings and additional disposable income. They do not take advantage of the ability to leave certain property within the estate because they simply don't list any there. Rand and Min also provide, under the liquidation analysis, an amount of $22,000 and propose to pay their general unsecured creditors that same amount. The plan is confirmed, and they faithfully make their Chapter 13 plan payments through automatic withdrawals from their bank account. In order to celebrate the 1-year anniversary of their plan's confirmation and their continuing payments, they go to the Meanwhile Bar on Wealthy Street. And good things happen at the Meanwhile Bar and bad things happen at the Meanwhile Bar. Good thing is they celebrated and had a wonderful time. But the bad part is that they were in no shape to drive themselves home because the trustee attacked their budget. They're simply out of funds beyond making their planned payments. Rand makes the terrible decision to drive, and as he's blessing and celebrating his bankruptcy attorney, Rand runs a red light and crashes into a car driven by Aleda. Rand, Min, and Aleda are all badly hurt and have to be taken to the hospital where they're put through a series of expensive tests, and Min unfortunately has to have emergency surgery. The insurance doesn't cover all of Aleda's medical expenses, and Rand and Min owe a lot of additional costs and expenses as a result of the accident. With limited options, they dive into Min's retirement account and withdraw $30,000 to help pay down some of the post-petition medical bills. Aleda, meanwhile, sues Rand and Min. Rand and Min, who don't want to disappoint their bankruptcy attorney, of course, don't tell him about the lawsuit. Aleda gets a judgment in her favor, an extraordinarily large judgment, which she tries to collect by all means possible, including wage garnishment, bank garnishment, and by seizing the Volkswagen, which was not totaled in the accident. Around the same time, Min realizes that something didn't go very well with her surgery. And after she consults with her doctor and her cousin, who's a personal injury attorney, she realizes that she's the victim of medical malpractice. Min's cousin files a lawsuit against the hospital. Rand and Min know that if their wages start getting garnished and their only vehicle is seized, they won't be able to pay their necessary household expenses and their Chapter 13 plan payments. They also don't want Aleda to be able to get to their bank account, especially once the settlement money comes in from the medical malpractice suit. So they see their bankruptcy attorney with writs of garnishment and orders for seizure in hand. They tell the attorney he needs to do something, anything, to protect their wages, vehicle, and their bank account because they have some pretty big plans as to how they're going to use the settlement money from the medical malpractice claim. In the same conversation they have with their bankruptcy attorney, Rand and Min mention that 6 months prior to the car accident, but post-confirmation, they accepted a rather generous offer for the purchase of their home in the amount of $350,000, which is $50,000 more than the value stated in Schedule AB. And from the sale of that home, they netted $100,000. Out of the $100,000, they used $50,000 as a down payment on their current home, which they think is worth $250,000. They used $25,000 on a European tour and Mediterranean cruise, and $20,000 on their daughter's extravagant wedding. The $5,000 that remained was deposited in their bank account. So many issues here confronting the bankruptcy attorney for Rand and Min, not to mention the Chapter 13 trustee, who's got to piece all of this together with no doubt some piecemeal disclosures. So the first question I'll direct to Ryan. Can Aleda commence suit in state court against Rand and Min?
Yes, I believe that is a possibility because when you're looking at post-petition claims, the state really only applies to property of the estate, not debtors themselves or debtors' property. So I think Aleda is free to go into state court, file her action. The difficulty comes when she's looking to execute on her judgment.
Okay, keeping that in mind, can she garnish and levy on the wages and bank account? And can she seize the Volkswagen?
Well, look at the wages first. Maybe luckily, we're going to look at what's property of the estate here. As the hypothetical stated, the debtors did not go with a default provision, so we don't have everything remaining in the estate. Instead, they used the opt-out or check the box, which states that everything's vesting in the debtors except for future earnings. So there's where we get the protection. So maybe luckily or thankfully, our model plan, no matter what you choose, future earnings or potential wage garnishment by post-petition creditors is going to be stayed if we have it in the estate. I think it gets a little more complicated when it comes to the bank account, you know, because again, they check the box and they didn't list anything in the other real or personal property necessary to fund the plan. So and then you start to ask the questions like, well, yeah, these are their earnings and they're going into the bank account. Does the deposit of those earnings into the bank account change the nature of the fund so much so that we're now outside future earnings and it's just simply debtor's property, so not subject to the automatic stay? So I think it's murky. So I think you can only really get clarity on this if when you're electing that box, that you're spelling out that the bank account is included or remains in property estate. I don't necessarily think that's the end of the analysis, though. You know, we referenced Kalinda earlier, and as the judge said, it's, while not binding, it's highly persuasive. Do we start looking at that and kind of thinking about what Kalinda thought vesting meant? Where, yeah, you know, they elected this opt-out provision or the box, and the bank account is the debtor's property, but maybe, you know, since we view this as, you know, we're using the preservation approach, which is what Kalinda chose, that vesting really doesn't mean that it was transferred fully to the debtors. It was transferred to them or vested in them so that they could use those funds in furtherance of the plan, or at least to the extent necessary for them to successfully complete the plan while the property still remains property of the estate. And if that's the case, then the stay is going to apply.
Okay, Beth, do you have any different view on this?
I agree with Ryan's analysis that I think the wages, they have a good argument that those should be protected and not levied upon, even under the provision in the plan, which I review as that provision. When they do check it, I think it's reminiscent of even the estate transformation approach. I think the default under the plan is estate preservation, which again was the approach adopted by the Western District Court of Michigan in the Kalinda case. But I think in this case, it is reminiscent of a state transformation approach. So I think the wages are protected. The bank account, I think, yes, is in a gray area. I think what they have to their benefit is the fact that in this case, they don't have a payroll order. So essentially, they are funding their plan from the funds out of their bank account. I think that would be their best argument. I think that they're sunk if you have a court that's going to interpret this estate termination approach. Again, I think that would have gone back to the debtor, and obviously the automatic stay doesn't apply then. In general, doesn't apply. That's, I would say, well-settled area of the law. There was a case now that just came down by bankruptcy, the bankruptcy court out in Colorado in 2020 in Ray Baker. And the site is 620 BR 655. In this case, they were dealing with post-confirmation appreciation in real estate. But what I found to be really telling in this case is that that court adopted the estate termination approach, but in fact indicated that despite that, the automatic stay is still in effect as to property of the debtor. I don't know how he was able to reconcile that with 362. He didn't really, to be honest with you, they didn't really touch upon it, didn't discuss it. But that's a huge case that's in debtor's favor. But I would say that in general, under termination, they're done for. They can go against it. I think when they're talking about estate preservation, it is protected. It remains part of the estate. The court doesn't need to get into a subjective analysis of was it necessary for fulfillment of the plan. It's in the estate. It's protected. They can't execute against it. So that's how I think that fact scenario would play out if it had to be addressed by the court.
Okay. Brian, what do you do as their bankruptcy attorney when Rand and Min show up and say, essentially SOS, how do we get back on track here?
Other than fantasizing about withdrawing as counsel?
Let's take that off the table in our hypothetical.
Well, I think we got to step back here and look at exactly what the plan states. We have to look at all the assets, figure out what they own here, what's property estate, what's for sure protected by the automatic stay, maybe figure out what may or may not be protected. If you're getting a letter from like a latest attorney or this post-petition claims counsel, I think you need to start formulating your arguments and trying to scare them away that, look, if you're going to execute on debtor's property, you're going to run afoul of 362. And here are the repercussions for doing so. That, I think, in my experience, is always been enough to get them to go away. But, when here, we're talking about a lot of money. And that that attorney may be real hungry to collect on that, get their contingency fee, so they may not just, take that letter and be satisfied with it. They may push it. So I'd be very nervous taking the issue in front of a court. I think I'd be consulting with my clients and trying to figure out what we can do to amend the plan, or maybe convert the case, or maybe look at non-bankruptcy alternatives like debt settlement, because things could go very badly.
At what point do you pick up the phone and say, Beth, do you have a minute?
Probably right after I got done talking to my clients. I think it goes a long way, and I've done it before. I've reached out to Beth and say, ask her, what's the trustee's position on this? Essentially asking, do you have our back? Because, they have an interest, they have duties. I'm sure that, Elizabeth can talk about, but the trustee has duties to administer the estate as is, right? I don't know how concerned they are about these post-petition creditors that are coming in and disrupting the distribution to that estate.
Yeah, Beth, what do you do when you receive a call like this, other than say, I'm going to need to call you back in a while?
I think after I would gather after gathering all the relevant information from debtor's counsel, I think the next step then is reaching out to what I hope that they're represented by counsel. Again, I'm forgetting her name, Eliana, with her counsel, reaching out them, indicating that it is our belief that there is a violation of the automatic stay. And I would advise them, I've had to handle this more in the divorce context, to be honest with you, but advise them they do have to file a motion for lift to stay, at least based on my interpretation. And if that's not done, then we may have to look at doing a motion for violation of the automatic stay. Because I think based on these facts, I would say the wages in the bank account based upon how the model plan is written, I think they're protected right now. And I do think the lift to stay would have to be filed. And so that's how I would handle it if I was getting the call from Ryan on this case.
Yeah, I'd be looking at this and thinking, probably based on the language of the model plan that was confirmed, there would need to be a motion for relief from the automatic stay that would be filed. I don't necessarily agree, though, if we have the estate termination approach. I think that's fairly open-ended. Let's fixate for a moment on post-petition medical malpractice claim. Is that property of the estate, Beth?
I think it is. And the cases that, now, if you read a lot of the cases discussing the interplay between 1306 and 1307, or I'm sorry, 1306 and 1327, there's an approach out there that is espoused as a fourth approach. And what that approach essentially says is the courts divide it right down the line. They say, okay, pre-confirmation assets at the time of confirmation, those go back to the debtor upon confirmation with the exception of future earnings. But when it comes to post-confirmation, those are an asset of the estate. 1306 is clear on that. And so one of the leading cases holding out that approach is Barboza versus Solomon. And the site to that is 235 F3D 31. And so that in particular dealt with, again, a post-confirmation appreciation in real estate. But it does talk about how, again, it becomes property of the estate clearly under 1306. A lot of the courts that have addressed post-confirmation, at least that we have found in this context, have addressed post-confirmation assets, have applied this approach, a modified preservation approach, where they have said, yep, it comes into the estate. In re Zazumbo, it's site 519 BR 851. That talked about post-confirmation inheritance proceeds coming over to the estate. In re Wetzel 381 BR 247 out of Wisconsin in 2008 talks about a post-confirmation inheritance and business income is coming over to property of the estate. So I think that it is going to be property of the estate. Whether you look at, again, that line of cases going under that approach, or even in the alternative, you look at even the 11th Circuit, they apply the estate transformation approach. But the 11th Circuit in re Waldron, and that is site number 536 F3D 1239, and that was rendered in 2008. The 11th Circuit recognized that in the prior case under Telfair, which was back in 2000, that they held the estate transformation approach, but they recognized the distinction between estate assets at the time of confirmation and assets that are required after confirmation. And in recognizing that, they determined essentially that a post-confirmation insurance settlement comes over to the estate. They didn't even do the analysis to figure out, is it necessary for fulfillment under the plan? They said, no, we can distinguish Telfair. It's coming over to the estate. So I think looking at the pattern of the cases, the only approach that I feel like the trustee would be sunk in saying it doesn't come over to the estate is truly if there's a court that adopts the estate termination approach. With the other three, I think that there can be an argument that needs to come over to the estate.
Randon withdrew $30,000 from the retirement account. Are those funds still exempt now, Ryan?
Well, here we have the problem that they've taken an asset, right, that's clearly exempt for a pile of cash. And now we're just saying, well, now is this no longer exempt, and it's just simply property of the debtors, potentially non-exempt property of the debtor. I mean, I think the debtor's argument would be that, this is one and the same as the substitute for that asset, and the exemption follows it. I guess the thing that I would be more concerned about is the trustee coming in and not necessarily saying, well, look, you disturbed the exemption and now it's not exempt, hand it over. But they're going to be waving 1329 around and saying, we want a plan amendment to capture this available disposable income. And so I think that's really where the fight's going to be. And the trustee, as I think most people know, they're one of the parties that have the ability to seek a plan amendment. But that doesn't necessarily mean a plan amendment would be a slam dunk. The debtor does have defenses against something like that, saying that the plan doesn't meet requirements under 1325A feasibility, because we have to look at why these debtors took the money out of the retirement account. They did it so they could pay for medical expenses. I can't think of anything that's more necessary So if that was the purpose of it and they don't have any other means to pay for those medical expenses, I don't really see it as disposable. So while, I think the trustee can make the argument that we have to look at the liquidation analysis again at time of at the plan amendments being filed, that can be overcome because we can defeat the plan amendment on feasibility grounds.
Beth, you have a different view?
Slightly. I do think that this issue is probably the most difficult issue in terms of this whole hypothetical, and is definitely in the gray area. And I have to say that I was pleasantly surprised, keeping in mind that I represent the trustee, in terms of finding out, based upon my review of the case law, I thought the case law was pretty much split in terms of, could a Chapter 7 liquidation amount essentially be revisited at a post-confirmation level, at a 1329 level? And I come to find out that, at least as the courts have regarded it, there's almost a majority line saying, yes, in essence, the effective date when it comes to Chapter 7 liquidation amount can be the date of modification. And that can still be revisited as long as you can meet a 1329 threshold for a modification. So as long as it's filed in good faith, let's say in this instance, on behalf of the trustee, and again, while it may not be required, it's a factor if there's a change in circumstance. And I think that once a debtor chooses to liquidate what, yes, previously was an exempt asset, I think those requirements are enough to at least warrant a good faith motion to modify under 1329. And then going again under the case law saying, yeah, we may be able to revisit that issue. Ryan brought up the issue though, obviously they've got a lot of postage and medical bills. If this were my case and I was representing Brett in this case, I would definitely take that into account in terms of whether or not we were going to pursue turnover of that. But I still think that it's eligible for turnover in a case. And again, it depends on what approach you use. I think that under the estate preservation approach, I do think it can be turned over. Estate termination approach, the trustee sunk. I think that under, again, that fourth approach where they're differentiating between pre-confirmation assets and post-confirmation, I think it could be eligible for turnover. So it really does depend on what approach the court applies. But this one I think is in the grayest area out of all of them.
Okay, let's move to the sale of the home. Who's entitled to the non-exempt proceeds from the sale of the home? Does the debtor get to keep those, or must those be paid over to the trustee?
I would argue that they would have to be turned over to the trustee. That still appreciation, post-confirmation appreciation in real estate or even other property does essentially need to be turned over to the trustee. Now, again, I think the only approach that would be against the trustee in that, again, would be the estate termination approach, possibly even the estate transformation approach in this case, because I think debtors would argue that they didn't select the real estate as being necessary for fulfillment of the plan. The funding of the plan was not relying upon the real estate, even from exempt proceeds, refinancing, sale. So I think that it's harder for the trustee to argue under the estate termination approach or even the estate transformation approach. However, with that said, I think even under the estate transformation approach, as I indicated previously, the 11th Circuit, again, which is being held out as almost the leading case of that approach, even understood the difference between post-confirmation and pre-confirmation. And so if this were my case, I would ask the court to basically use that as guidance in saying, okay, estate transformation approach is good for pre-confirmation asset, but now we have essentially a post-confirmation because they decided to sell it. We need to essentially utilize those assets and determine that in essence is property estate, because 1306 is in play, 1327 is out the window. It doesn't even apply. But I think I would use definitely for support of that, the First Circuit in Barboza versus Solomon. And that was right on point in saying, yes, post-confirmation appreciation of real estate inures the benefit of the estate. You do have other cases. The 10th Circuit Bankruptcy Appellate panel just came out recently. And that's a Westlaw site. It's 2020 Westlaw 586-9458. It was actually just rendered in October of this last year. they did indicate that post-confirmation appreciation cannot inure to the benefit of a Chapter 7 estate when a Chapter 13 estate is converted to a Chapter 7. So that ruling, in my view, is very limited. It's limited because it looked at the language of 348F and essentially said, well, when you're dealing with a converted Chapter 7 case, you have to look at the petition date. You basically aren't allowed to look at the confirmation date or post-petition. But that same court recognized that there is a distinction between estate property in 13, that it doesn't just deal with estate property at the petition date, that essentially there's still estate property that can exist after the petition date. So I would like to believe that even if that same case was brought before the 10th Circuit Bankruptcy Appellate Panel, that they would have decided on a case that didn't convert to Chapter 7, that in essence, they may still have determined that post-confirmation appreciation is still property of the estate. The other case that, again, goes against that and talks about post-confirmation appreciation not inuring to the benefit of the estate, that is the In re Baker case, and that was rendered by the Bankruptcy Court out in Colorado in 2020. And again, that case that is 620 BR 655. But again, they adopted the estate termination approach. And so in determining that, they determined it doesn't go over to the estate. So I do think, again, the trustee has sunk if the court's is gonna look towards the estate termination approach, but I think he'd have a good argument for the other three approaches.
Ryan, once again, you're handed this mess with the sale, and you're stuck with the model plan that we have, which requires you to seek court approval for any sale of real property, regardless of whether it's in the estate and the effects of vesting. What do you do when you learn that the property was in fact sold already? How do you seek non-pro-tunc relief, if at all?
Well, I think we're sunk on that. If we look at Roman Catholic Archdiocese of San Juan, Puerto Rico versus Feliciano, the Supreme Court said that federal courts may issue non-pro-tunc orders to reflect reality of what has already occurred and presupposes decree allowed or ordered but not entered through inadvertence of the court. Non-pro-tunc orders are not for revisionist history by creating facts that never occurred, in fact, or for the court to make a record of what is not. The other day, when day one of the seminar, Kurt Steinke, the staff attorney for Barb Foley, brought up that they're now, instead of encouraging or entertaining non-pro-tunc orders for things like this, instead of encouraging debtor attorneys to file motions for forgiveness. I guess the other thing I would be sweating about is, whether this is a material default under the terms of the confirmed plan. I suppose that's maybe where the motion for forgiveness comes in. But I would kind of actually like to go back. I don't know how much time we have left, to the last question, because I don't think the debtor's perspective is being fairly represented in Beth's response to what happens to those net proceeds. I think you're looking at 1306 and 541A6, and you're looking at what's coming into the property estate. And obviously, as Beth said earlier, 1306 is incorporating all the assets that are identified in 541, which includes 6, which would be proceeds, or arguably the net proceeds from, or the excess net proceeds from the sale of the property. But in our hypothetical, the debtors didn't keep the property in the estate. They didn't list the house as one of those additional pieces of property, real property necessary to fund the plan, so they vested it in themselves. And 541A6 only applies to property of the estate. So, if they're removing the property from property of the estate and instead naming it debtor's property, I don't see how 541A6 applies. And so I think those proceeds are the debtors. Now, I have seen arguments that proceeds should be viewed as a new asset, It's separable and distinct from the homestead itself, and that's how it comes in. But as a debtor's attorney, I'm going to go ahead and disagree with that. So again, I mean, I think if you view 1327B as permanently removing the home from the property estate and the jurisdiction of the court, I don't think the court has a basis for looking at the disposition of those funds. But again, I mean, we've got this problem for the question I just received. We just sold it without permission, and that was one of the terms of the confirmed plan. And I've got the trustee hungry for that money and waiving 1329 in front of us. So while I can argue that it's the debtors, I've got a whole other host of issues I've got to deal with and resolve with the trustee. But, you know, in my mind, at least I've got something to argue to the trustee so I can work out something reasonable. Because in all honesty, I'm not sure that this is something I want to take in front of the court and get a decision on.
Okay, we are dangerously close to running out of time, and I don't want to impinge upon the next panel's time. Beth, last words about this topic, which we have discussed, but arguably not provided much clarity with respect to?
Just one final point is that, and Ryan's point is very well taken, and I know initially it seems like an unsettling concept to think that maybe Chapter 7 liquidation analysis can almost be revisited at a post-confirmation level. And I frankly was shocked by the fact of so many courts that I've seen being able to say, yeah, you can essentially, revisit it. And in this case, in this hypothetical, we were dealing with appreciation in real estate. There will be a day, and maybe we've seen it now starting to come through, that the opposite could also occur where, the value of the real estate could essentially decrease after confirmation, and they might have to sell it for less than what they had valued. And so it might inure to the benefit of the debtor at that point, because then maybe they won't be held to that higher, either the Chapter 7 liquidation amount in the original plan or the commitment to sell it for a certain amount. So I think it can go both ways, that ability to possibly revisit the Chapter 7 liquidation amount. And so I guess that's my only, maybe to even appease debtors counsel, that it can go both ways. And so there might be a light and a silver lining there with all of that. But that's all I wanted to say, as to that point.
Okay, thank you. Ryan, any final words?
Yeah, and I think that's a good point. I won't beat that one to death. And I think Brian Rookert had pointed that out, saying, what's good for the goose is good for the gander. So yeah, if we're only picking one measuring date for 1325B liquidation of liquidation value or best interest of the creditors test, it can't cut both ways. If we're going to insist on one measuring date, if we're into the plan later on, it may not give us any room to maneuver to try to make the plan feasible again. One thing I didn't address in my last answer that, I think people need to look at 348F. I know Elizabeth was talking about that. When I read that and I look at courts that are addressing that, I really see it as they're saying, the courts in the legislative history behind it is really saying, like, look, we don't want Chapter 13 debtors to be worse off because they didn't initially choose to file a Chapter 7, right? We're not gonna make all this property that they acquired over the course of the 13 all of a sudden become property of the state upon conversion, unless there's bad faith. And there's thought that really the Chapter 13, this is the bargain that debtors are making. They're going to say, okay, this is what I own, this is what I'm going to pay, I'm going to meet this liquidation analysis, and I'm going to pay X amount of dollars over this period of time, and I get to keep all my stuff. Whereas in Chapter 7, you're liquidating your assets. So when you start to look at post-petition appreciation, it really is, if the debtors aren't getting any benefit out of that, I think it can be a big disincentive to file Chapter 13. I think it's almost punitive. But I just want to throw that out there because I don't think that 348 it should be ignored. I think it should be reviewed. I think it's something that needs to be taken into consideration and kind of helps debtors counsel in thinking, how these post-acquired assets really should be treated throughout the course of the bankruptcy.
Okay, I'll have a final word, and it's more of a question to think about. That's if you endorse the estate termination approach and there is a non-exempt piece of personal property that is disposed of without court authority by the debtor, and the case later converts. How does the Chapter 7 trustee realize the value of that asset for the benefit of the Chapter 7 estate in light of Section 348F1? I don't know the answer to that. I look forward to reading Judge Boyd or Judge Dale's decision. So if you have that issue, please direct it to them. With that said, thank you for everyone's time. Thank you, Beth and Ryan. It was quite enjoyable to do this with you.
Thank you.
All right, thanks, guys.
Thank you.
All right. We have the student loan panel up next. We have Carissa Potts and Careless Lassner. Welcome from the east side to the west side. I'll let you guys get to it. I don't want to take up too much of your time here. We already have, so welcome.
Thank you, Ryan. Yeah, thanks, Ryan. So good afternoon, everyone. My name is Careless Lassner. I do practice in the Eastern District of Michigan, primarily in Detroit, but I also appear in Flint from time to time. Back in my days as a creditor's attorney, I did appear on both sides of the states. I even went so far as to attend a hearing in Marquette. So I practice primarily debtors work now. And what I'm going to be talking about is Chapter 13 student loan treatment. I am not sophisticated enough to have a PowerPoint, but I do have some summary of my materials. There's no way for me to get through everything I would like to share with you in the half an hour or so that Carissa and I have agreed that we're each going to take. So what we're going to talk about are fresh and modern concepts for Chapter 13 treatment of student loan debt. And this is not a tell-all. This is not that I have all the answers, but we just want to talk about some modern ideas and arguments that I've advanced in one notable case. I've made smaller arguments and had success to some degree in other cases, but there is one case in particular that I think is noteworthy because it required the most amount of research and analytical arguments, both in briefing as well as before the court.
And you know what, Kara, before you launch, Kara and I discussed prior to this that everybody may, of course, keep their camera off, but it is rather dystopian to talk to an empty audience. So if anybody would like to have their camera on and engage in a conversation, we're encouraging questions as we go through this. We would love to see your faces and hear your voices.
Yes, thank you for Carissa for remembering to mention that, because the only reason that I prepared this PDF file is because I didn't want to stare at a bunch of black screens with your names, as delightful as that might be. So the materials that I provided and that Ryan forwarded to everyone, or the debtors bar forwarded to everyone, they're just intended to be thought-provoking. Like I said, I don't have all of the answers, but in preparing to argue and defend against trustees' objections to confirmation in a particular case, I was forced to make some creative arguments to the court that I deem to be ultimately successful. As I've already said, no one has the answer, but we can do what we can to put our clients in a better position when they emerge from Chapter 13 with student loan debt than historically we've been able to do. And speaking of history, it's very important that we understand or have a refresher of how the student loan debt became the crisis that it is today, at least in the context of a Chapter 13. So back in the early 70s, there was a trend of students who would graduate from school, undergraduate, graduate, as well as professional degree holders, and they would immediately turn around and file bankruptcy. Some of my early research indicates that this wasn't as widespread and prevalent as the legislative response would have us believe. However, nonetheless, that's what happened. So therefore, in the mid-70s, Congress responded with a number of different legislative moves that ended up resulting in you had to be in repayment for a period of years, and that those years went from 5 to 7, and then ultimately evolved into where we are today for all intents and purposes, and that is that you have to die to get out of your student loan debt. At least that's my position, but Carissa's going to speak on maybe another way to get out of it. The bottom line is that as of the end of third quarter 2020, according to the reliable sources, Americans owed $1.566 trillion in student loan debt. It would be my estimation, according to the proof of claims that get filed, that the vast majority of that is actually student loan interest. So while the courts appear to be trending towards accepting new ways to consider student loan debt and what we can do with it, whether it be in a Chapter 7, whether it be an adversary, which Carissa is going to talk about shortly. In the world of Chapter 13, at least in the Eastern District of Michigan, we have traditionally treated them and been required to treat them in a Class 9 general unsecured claims, which for our model plan is where unsecured claims go. I certainly could not, in the last month, since knowing I was speaking at this conference, I could not become an expert on the Western District plan. However, I did spend quite a bit of time looking at it, and I see that you also have a provision of where student loan debt is supposed to be listed if you're going to separately classify it. But let's think about what types of debts are listed in a plan, because whether you're in the Eastern District or the Western District, the idea is that student loan debt is unsecured debt. That is an absolutely true statement, but that ends the inquiry, and it's my position that it shouldn't. Because if you think about it, we have secured and unsecured and priority claims and non-priority claims and tax debt and non-tax debt and debts that are co-signed by folks and debts that aren't. We have all kinds of different types of debt, and it's my position, and I think it's a successful and winning argument that just because the debt falls into one particular type of category or classification does not preclude it or trump it from falling into another. So when you're going through and you're evaluating the types of debts that your clients have, and we're talking in particular about student loan debt, it's my position that not only is it unsecured, it's also continuing, because chances are there's no way that that debt has a date certain end date. So it certainly is going to last longer than 5 years, even longer than the 8 years provided under the CARES Act for post-confirmation cases. It's somewhat contingent depending on your client's circumstances. And keep in mind that throughout this presentation, I'm talking about substantial student loan debt. In my particular case, it was over $190,000 at the time the case was filed. But so it falls into numerous different types of categories that just haven't traditionally been itemized out, so to speak, in a Chapter 13 plan, whether that be pre-model plan or current model plans. We stick it in unsecured and we leave it there. And that doesn't mean that that's where we need to leave it. And the bottom line is, while we haven't been doing it wrong all this time, we really need to do a better job now as the courts are leaning towards better treatment and more understanding and finding ways to make that happen, that we take advantage of that and capitalize on it when it's appropriate. So let me just touch on that for a moment. It may not always be appropriate to take this stance that I'm going to outline today, because if your client has a very low surplus on J, so a very low Chapter 13 plan payment, it may not be advantageous to them to separately classify the student loans. If the balance on the student loan is particularly low, it may not be advantageous. Sometimes you might be able to treat it as a special unsecured, which is what we do here in the Eastern District for a variety of debts, not just student loans like the Western District has a breakout for. So once we determine how many categories a student loan falls into, and in my case, it was a continuing claim, a non-dischargeable debt, and an unsecured creditor. So my position was, argument for today, student loans may be treated alongside mortgages, those long auto purchase contracts, those 84-month contracts, and that they are continuing claims.
Carol, what are the situations where you think it's ideal to put it in, as a continuing claim?
I think when we've got a contractual payment, monthly payment, great question. When we've got a contractual monthly payment that rivals a higher end vehicle or a mortgage payment, then I think you need to be looking at this. In this particular case, and I'll flip ahead here to some of the information that I put together. In this particular case, which was In re Quinn, an Eastern District case out of Flint, filed in 2017, and this particular issue was argued in 2018. The debtor owed, as I said, $192,000 of their total $219,000 in unsecured debt. Their contractual payment was more than their mortgage payment. Their mortgage obviously has a set rate of interest, but at the end of their Chapter 13 plan, they were going to have a lower mortgage balance than they started the plan with. Under the plan we proposed and the treatment of the student loan claims as continuing claims alongside the mortgage, we proposed less than the contractual amount because that contractual amount was too high. And of course, they can't get interest, but the interest continues to accumulate. Even at the $850 a month that I proposed, at the end of the case, the debtor's balance would only be $215 less than it was at the time the case was filed. So this was a prime case. This was a beautiful case to argue. You're not always going to have great facts in favor of that, and that's when you need to go back and, again, evaluate with some of these ideas, because that's what I'm proposing today are ideas. You go back and you evaluate and apply it to your case and determine whether or not it makes sense, whether or not it's worth the attorney fees that are going to accumulate, making the argument, advancing the argument, perhaps doing the briefing, having the extended oral arguments before the court, which back then were in person. All of those things come into play, and the debtor's overall financial situation. Without going too far astray, I will say that at one point, Judge Opperman, who was still sitting in Flint at the time, it was before Judge Applebaum took the bench, but Judge Opperman specifically asked, what was the client's earning potential? What was the client's improvement potential? And in my case, the debtor wife worked in a nonprofit, in the nonprofit sector. She had, short of becoming a director of a nonprofit organization, she had reached the highest level within her organization and within any similar organization. So her earning potential was really tapped out. Short of leaving what the clinical side, which is what she was doing, she would have had to have become a director, and that would not have even resulted in a substantial increase in her salary. So going back to, there we are. My suggestion in looking at the plan for the Western District of Michigan would be to rename Section 3C of the model plan. C3C, I believe, is currently named secured claims. And looking through it, I saw, well, that made sense because everything that's there looks like it's, related to a mortgage, real property, or one of these longer term cars, but I may be misspeaking on the car claim. If you put continuing in, which is essentially the same thing, although it would also, by leaving secured claims in the title, include those post-petition property taxes, pre-petition property taxes, those types of things, then you would add a section 3.6 or 3C6 that would be specifically for student loans. This was my attempt. Again, I'm not an expert on your plan because every district's different, and I'm not familiar with the evolution of case law on the court level. But This would mirror essentially what I did in the Eastern District of Michigan, where I moved that student loan from class 9, which is our general unsecured, into class 4, which is our continuing claims. That's where we treat our ongoing mortgage, arrearages on the mortgage. And this was a pre-current model plan. So today, we have a section in our class 4 that includes non-real estate continuing claims. So it alludes to the fact that you could probably put this type of a claim in there. However, at the time, it was just mortgages, or rather secured continuing claims that had a due date past the end of the plan. And
the code specifically says it can be secured or unsecured. So, and our model plan still now, even the revised model plan says it has to be secured, and that's not what the code says.
Right, and that is part of my materials, because there is not a requirement under the code that dictates these particular classifications that we have. There are various provisions that require you to treat various claims a certain way, but just because those provisions exist and there is an absence of the others does not mean that other claims can't be treated differently than we currently treat them, whether it's the Eastern or Western District. So that's a very good point. You have to go through 1322 and 1325 in great detail to make sure that what you're doing does comport. It's my position that what I propose and the treatment that we're talking about today in particular fully complies. And I go into that in some detail in the materials that have been made available to you, but much more detail in the briefs that were filed in the Quinn case. And those briefs start, I believe, at docket 45, because I believe my brief was due prior to the trustees. But I would encourage anyone who wants to delve into this further and see the arguments that are developed, both read my briefs as well as Melissa Coette's briefs, because as the staff attorney for the trustee, and of course, just based on her experience, her vast experience as well, she's very intelligent and has very well-developed arguments, even though I didn't agree with them. And I think that the outcome is different than what she was proposing. So the objection that the trustee essentially files, among other minor objections, I'll say, is that the treatment discriminates. Well, the code doesn't require that all claims of the same kind be treated the same. It requires that there not be unfair discrimination. Some of the arguments I advance to overcome that is that student loans are only unsecured in the very common form of the word. All of those types of classifications that I alluded to earlier, continuing claims, priority claims, tax claims, so on and so forth, co-signed claims, claims for student loans that weren't taken by the debtor for the debtor. These Parent Plus loans, there's a whole nother world of argument that can be made there on why they're different. So first of all, that's the position, is that they're only unsecured in the most basic form, because the characteristics of these claims are so vastly different that they deserve and they need to be treated differently. Consider that the debt has an unknown repayment period. It could be 10 years, it could be 30 years. If legislation changes, if Congress passes legislation that expands that, it could end up being longer, it could end up being shorter. If you have a type of job in the public sector that is subject to forgiveness, or that changes the term of your loan, then that's another factor. All of those things were not contemplated and taken into consideration when the loan was issued. As one judge put it in In Re Engine, it's a mortgage on your future. And so there's no provision that says this is how much your plan payment or your mortgage payment's going to, or your student loan payment is going to be. This is exactly when you're going to start making repayments. There's just all of these factors that come in. It's a debt owed to the federal government. There's no creditworthiness that's required to get these loans. The balances continue to capitalize at a rate that outpaces any earning potential and any increased earning potential that a debtor might have. That default can result in a garnishment being issued with no court action whatsoever. The federal government can garnish you up to 15%, including Social Security. So all of these factors were factors that I identified that were true and accurate at the time. I think that they're still true and accurate, but what I submit is that there may be additional factors that are now true and accurate that could further the argument. Default on the debt, as I said, can result in not only garnishment of Social Security, but federal income tax refunds as well, which currently isn't the case. And that public policy supports more prompt repayments of debts to the government than it does to like a Visa or a MasterCard. Now, of particular note is that public policy arguments were asserted in my brief at docket 45, starting on page 11. If you want to read more about that and get your juices flowing on how you might also argue for this more favorable treatment than has been traditionally allowed. Consider also that on the higher end of the borrowing spectrum, again, as I said at the very beginning, people typically need to die before they're going to be able to get out from underneath this debt. The exception is going to be if they are successful in an adversary, which we've been seeing across the country. Of course, we don't know what's going to happen on appeal of those cases. Carissa is going to talk about APs here in her segment, and so I don't assert that that can't be successful. However, that is the only tried and true method. If you die, you don't owe the student loan debt. So here's again the reference to the Quinn case, case number 17-312 or 32180. There was a brief, a response brief. We may have had a brief again, and then the court issued an opinion. Don't stop there, because that opinion sustained the trustee's objections, but that wasn't the end of the argument. So as I said, I originally proposed to treat this with $850 a month to be paid over the 60-month plan with 0% to unsecured creditors. The trustee's assertion was that, number one, this wasn't permissible treatment, but she was willing to resolve for 50% of whatever the dividend would be to the student loan creditor. So, for instance, if her calculations showed that the student loan creditor would ultimately receive 30% of its claim through the life of the plan, regardless of what the ending balance truly would be, she would settle the case if I promised 15% to unsecured creditors. So that's another possible outcome, and that was ultimately the outcome in this case. But maybe you've got better facts, and maybe you want to press that issue a little bit more. This is what we ended up resolving with, and that's what Judge Opperman ruled in that case. And so I think it was a fair outcome given all the circumstances. I think it's unfair in general that student loan creditors will emerge from bankruptcy with higher balances than they did when they went into bankruptcy, but that is maybe just the next step in these baby steps that we can take to better treatment. As I said, my end result was that I got the case confirmed. They did have to pay at least half the dividend to unsecured creditors, general unsecured creditors, of the dividend that the student loan creditors would be receiving. It was a win. I referenced earlier the In-Rate Engine, ENGEN. There's the site right there. It was the best case as of the spring of 2018. This case is also referenced in my materials and extensively referenced in my briefs. This was my favorite case, is still my favorite case. The judge in that case went through and examined 10 different evaluative tests. He then gave, credit or discounted of those 10 tests, the ones that he thought were the most realistic, the most appropriate, so on and so forth. He then went through an extensive discussion of legislative history and applied the law to the particular facts of that case. I found it to be an invaluable resource. It was very well researched and very well written. I will say I am very disappointed, as I presume many of you are, with the flow of this presentation that I've just presented to you. I will say that there is no way that we can cover all of the thoughts and arguments that could possibly be raised to treat student loans differently in a 30-minute period. We just can't.
Kara, can I raise like one question that's kind of on the chat and I think is on people's
Oh,
minds?
sure. And I'm sorry, I didn't even see the chat light up.
Oh, well, that's what I'm here for. I'm here to help.
Thank you.
We're the teamwork. What about where the got an income directed repayment? Do we put that in class I always want to say class 4, but that's what it is for here. Can we put that in our continuing claims?
I would further argue that an income-based repayment at this point in time, and again, this goes back to what, Congress may or may not do at some point in the future, but an income-based repayment will result currently, based on current law, in a taxable event at the end of that period. So not only would I put it in a continuing claim class, or in the Western District, the secured claim class, I would propose to pay more than the IBR requires, because ultimately that balance is still accumulating. All these folks who got relief under the CARES Act the first go around with student loan debt, they may not be accumulating continuous interest because of the CARES Act, but once that expires, they're no further ahead. The CARES Act and the activity that Congress outlined under the CARES Act for student loans only served to freeze everything in time. But what about all of the income that folks have presumably lost over the course of the last year because of COVID and the pandemic, and whether you were directly hit in your industry or you're like the bankruptcy world, experiencing an ancillary result of people, being out of work, but maybe not in a position of dire straits yet where they need to file. The bottom line is, my argument would be that that was just simply a freeze frame, and that on a go forward basis, we need to be looking forward, just like schedules I and J do. This is a forward looking proposition, that you could go ahead and treat that as a continuing claim. Now that you say that about the chat, though, let me just pop up this and see. Okay, see the IBR. Was there anything else you noticed, Carissa?
That was
Brian. I want to speak to Brian Rickard. I'm so glad that you're so involved in this, Brian, because yes, Brian absolutely has been doing creative things with student loans for quite a while. Oh, Cheryl Chadwick. If you email me, I will send you my materials. I don't know why they would be full of special characters, so we can make that happen. Oh, Judge Gregg, thank you for citing a case. Oh, looks like that was from his prior materials. Okay, perfect. I think that hits everyone. Let's see. Yes, Kristen Kroll, that's an excellent point. Kristen says the debtor should still propose a payment of greater amount for the term as a continuing claim, because there's no reason for any funds to go back to credit cards when it can go to keep that student loan debt balance down. That's absolutely the objective here. And so that's a great point. So again, and I'll just close up real quick so that Carissa has, the time she needs to present her materials. And frankly, I'm looking forward to being educated from her experience. Folks, this is not typically the flow of a presentation that I make. However, again, I can't hit all of the ideas and suggestions in a 30-minute period. It's just not possible. That being said, that's why I drafted my materials around thought-provoking and just getting folks to a point where your juices are flowing, and we're not just going through the motions of filing a plan. We really need to think about a more all-encompassing approach to our clients. And I would say that many of us have always done that. And I imagine that the folks who are on this continuing ed today do that and have that approach. But with all of these advances that are being made across the country, the bottom line is take advantage of it. Try and press that issue a little bit more. But again, you want to evaluate whether or not it makes sense. And if anybody has any questions, wants to talk about a particular fact pattern or situation, please, please, please feel free to email me or give me a call. I'm a student loan bankruptcy nerd, so I love to talk about this stuff. And I'm happy to brainstorm through with you and see what makes sense and see if I can't give you more ideas and suggestions. And with that, I will turn it over to you, Carissa. And again, thank you, everyone.
Thanks, Kara.
I'm gonna stop my share now.
Okay, and I'm going to
There we
start
go.
mine, so hopefully this will go okay. I practice with Kara over here in the Eastern District, and I'm going to be talking to you more about how to do an analysis when somebody comes into your office with, and again, like Kara, we're talking about people who come in with really large student loan balances. These are the ones that, it kind of makes your jaw drop sometimes. And how do you get your arms around that? And how can you help them? And also, how can you make money? That's an important aspect of it. Okay, I'm going to attempt to start my PowerPoint. So the way that I'm going to be talking about this is I have an outline with stuff that you can refer to, but then I'm going to be walking you through an analysis, an actual case study of a person I had that we got a very good result. And again, a very good result in this case was a settlement. I didn't, win at the Sixth Circuit or anything like that, but it was a settlement that my client was very happy with, and so I consider it to be a success. Okay, so sorry, this will just take me a moment here to figure out how to screen share.
Well, while you're doing that, and so until we see it pop up, are you familiar with the student loan lawyer?
Yeah, Josh?
Yeah, Josh Cohen, because he might be a great resource too.
He is really great. He is a good resource. I will say that he actually, okay, can you see this?
Yes.
Okay, great. He is a good resource. He operates out of like New Hampshire, Vermont, and he is a really knowledgeable, really smart guy. And I have bounced things off of his head many, many times. Okay, so client comes into your office and has just hundreds of thousands of dollars of student loans and is in a mess. And so, what do you do? Well, first step is, I think, is extremely important reminder is we want to figure out a way to get paid for this. And so I want to caution that before you get into an analysis with somebody who has pretty significant student loan issues, you want to make sure you're getting paid for that analysis. Because even the analysis of figuring out what's going on, because the people who have big problems tend to not have a really good grasp of their situation, I find. So the ones who need your help, make sure you're getting paid for this analysis because it's very time consuming. And then obviously, if you're taking additional steps to remedy the student loans one way or another, again, make sure you're getting paid for this because it is very time consuming and it can provide a very significant benefit to your clients. Okay, so somebody comes in, they have a lot of student loan debt. So the first thing we want to figure out here is, we want to figure out if they're federal, if they're private, is it a combination? We want to get some facts from our debtor, what's going on, what is their situation? Okay, so the situation that I had was somebody called my office and we're going to be calling him Eric. Okay, and so Eric came from a part, he actually lived pretty far away from where I practice, and he was referred to my office, and I'm still not sure who referred him. I was never really able to figure that out, but he came to my office And he said, oh, I understand, you know, you can help me with my student loan situation. And at the time, I actually wasn't really familiar with all the different things you can do in student loans. And so, but never wanting to disappoint, I said, of course, I will help you out with this. Let's see what we can do. Okay. So a little bit of a factual background. He's 30 years old. He's in good health. He's married. He's got 2 small children. Really no assets, no real estate, nothing like that. Has a 401k with a small amount of money in it. He works as an aviation technician, and he's got his certificate to do that. He has a salary of $52,000 a year. And if he works all of his available overtime, he can make up to like $72,000 a year. As one can imagine, with a wife and 2 small children at home, his wife is not particularly excited about the 60 to 80 hours a week he was working to make that extra money, but that was kind of how they were able to get by. His spouse is a licensed hairdresser. And after she had their first child, she tried to go back to work, but the child care expenses were exceeding what she earned as a hairdresser, so she had to quit. And she has her own federal student loans from hairdresser school. And their household expenses are fairly low. Their budget was frugal. And their sort of credit card debt, random other miscellaneous debt is about $15,000. Okay. So let's see if I can, all right, yay. Okay, so some background on his education. He attended ITT Tech from 2004 to 2007, did not receive a degree. After that, went to Lawrence Tech, did not receive a degree there. Finally ended up at this MIAT Tech College, and that's really where he finally got a certification to do the aviation maintenance, which is what he's certified to do. And anecdotally as well, what he was earning, the $52,000 a year, that was the top of his earning capacity, again, without working, unless he worked overtime. That was really, he was kind of capped out. He was about in the 95th percentile of what he would be able to make, okay? And so since 2014, he's been paying consistently $900 to $1,200 a month towards his private student loan debt. That does not meet the minimum payments, which are about $1,590 a month. And he's been keeping his federal student loan debt in deferment or forbearance since that time because he couldn't afford to pay anything more than he was paying on his private student loan debt. And in his mind, he figured, well, my private student loan debt has a higher interest rate, so I should be concentrating on that, which that makes sense. I can see where he was coming from, you know, but he was desperately trying to get a handle on it, okay? So, the first thing I wanted to do is, again, I wanted to figure out, wrap my arms around his student loan debt, what its composition was. And so, because there's different things we can do depending on the kind of debt it is. And so we want to figure out which of these is federal loans, how much of it, and what is it comprised of. So the place to figure out student loans, whether they're federal, that is going to be the National Student Loan Data System, nslds.ed.gov, and that web address is in your materials. And that will provide you with an exhaustive summary of the federal student loans for an individual, okay? And, you know, that's always, I think, going to be your starting point, because we want to find, because federal loans, obviously there's certain benefits. There's fixed interest rates, there's income-driven repayment plans that are available. But it's important to get them under control, because if they go into default, they can start garnishing your federal tax refunds. But there's so many options available and flexibility provided. It's important to figure out which of these student loans are as a result of the federal student loans, okay? So I went to NSLDS and downloaded his summary. And what I found out is all of his—
Carissa,
yeah.
Just real quick.
Yeah.
Can you tell everyone what that acronym
Oh,
is?
Yes, the National Student Loan Data System. Thank you. Absolutely. So, essentially he had consolidated his student loans in the past, which is good, excellent. And the current balance was about $51,314. Okay. Of that, I was able to determine that about $11,000 of it was federal loans given to him while he was at ITT Tech. And that's an important point that we're going to come to in a minute, okay? So he had not paid anything on those student loans for 5 years. So this to me was like a no-brainer, okay? So what's his solution for federal student loans? And this was a solution that has nothing to do with bankruptcy. This is just, him coming in, 11,000 of those federal loans were attributed to an education ITT Tech. Well, ITT Tech is one of those for-profit schools that went defunct in 2016. And so there was a class action lawsuit filed against the Department of Education. And so part of that settlement with the class action lawsuit was that students who have federal loans only that were taken out in connection to this defunct university, and there's some other defunct universities as well that were included in this class action and other class action lawsuits, they can apply for forgiveness of those debts. Okay, so that's step number one. So right there, we just knocked out over $11,000 of federal loans. The remainder of the federal loans, let's get into an income-directed repayment. And the rest of his student loans were already consolidated, so normally we'd want to make sure that step was completed first, but his were already consolidated. So what was remaining after we got the forgiveness of the ITT Tech federal loans were put into an income-directed repayment program. The payments were about $200 a month, and he was very, very happy with that, okay? And there's now an end in sight where if he makes all the payments pursuant to the IDR, eventually he's gonna have, a forgiveness of the remainder. So this was a great solution for him, no bankruptcy involved, okay? So now, okay, we're gonna be turning to private loans. Private loans are very, very, very tricky. Okay, because there's very little that can be done. So just like there's lots of options with federal loans and they're flexible, with private loans, you're at the mercy of the creditor. Okay, they are unilaterally decide whether there's any forbearance options or repayment options for you, and their collection activities tend to resemble the collections of other unsecured creditors like credit cards. So they can be very aggressive, but they must also obtain like a state court judgment in order to garnish wages, bank accounts, or that sort of thing. And by the way, they're also subject to a statute of limitations. So that's always an important thing to remember, okay? It's important to remember to also try to resolve things with private student loans before the debt is reduced to a state court judgment, because things definitely get much more difficult once there is a judgment. Here, Eric had been, again, attempting to make payments on these private student loans for 5 years. There was no judgment involved, so this was a little fortunate. So I made a spreadsheet, whoops, sorry, okay, I'm new at PowerPoint. Okay, so I made a spreadsheet of all of his private student loans, which were all serviced through Navient. Some were from ITT Tech days, some were from the Lawrence Tech days. And I also created lots of other information that I thought might be useful to me. So I had balance, I had sort of a record of the payments he was making on them, when he was expected to pay it off, all this relevant information, because I felt like this was important for me to get a handle on the situation. So now, the next step is, well, now what do we do with it? Okay, so first thing we want to do is, what are our options outside of bankruptcy? Okay, and, he doesn't have a lot of good options outside of bankruptcy because, he doesn't have any like large lump sums to try to settle with them. Statute of limitations is not on the table here. He's made payments within the statute of limitations, so that's not really going to do anything. And so the other options, well, what about like maybe a refinance? Is that going to work for him? So I ran through some hypotheticals, and these are, I had probably 5 or 6 different amortization hypotheticals I ran. So with this current balance of $170,000, the average interest rate was 10.22%. And the interest rate on the loans range from 7% all the way up to like 15%. In 30-year term, he had to make $1,500, $89 a month for private loan payments only to pay it off in 30 years. And again, he had been attempting to make payments on it for 5 years, was paying $1,200 a month, and that's not even covering the interest payment. So he would never pay it off. And the only way to pay it off currently was to make these very large payments that he cannot afford. And again, this is not even withstanding his wife's student loan payments or any payments on his federal student loans. So at the time when I looked at this, the best refinance interest rate I was able to find on student loans was 7%. So, okay, well, what if we were able to refinance at 7%? He would still have to make payments of over $1,100 a month in order to pay it off in 30 years. And that's under a best case scenario. And there's just no way he could afford that. And he, that combined with other student loan payments would exceed his, more than half of his like monthly take home income. And so this was not something feasible that he was going to be able to maintain. So, the refinance option was really not going to get him anywhere. Okay. And so, well, now we got to look at what about bankruptcy, right? Is that going to be a viable option for him? And so, we, under 526A8, there are 4 categories of debt that are excluded from discharge under the code, okay? And the first one is loans made, insured, or guaranteed by a governmental unit. Again, that doesn't apply here. These are private loans. And number 2 is loans made under any program partially or fully funded by a governmental unit or nonprofit institution. That doesn't apply here, so that doesn't really work. And 3 is funds received as an educational benefit, scholarship, or stipend. So this is kind of interesting, and because there is some case law on this, and it is included in your materials, and the definition of what are funds received, and is a tuition credit, and courts have found that a tuition credit from a nonprofit is dischargeable because there was no actual funds received. Also, what is an educational benefit? And there's some interesting case law on this too, where certain kinds of educational related conditional grants are found to be dischargeable. Or, and examples of this include like a bar prep course or a med school exam prep fees and books and rent and living expenses while a physician was studying for her med school, or a future physician was studying for her med school exam. So these are interesting examples of where courts have found that there's no educational benefit. And so it's technically a dischargeable debt. Well, there's really fun part when we get to the 4th kind of debt excluded from discharge. And that's any qualified educational loan, as that term is defined in the IRS code. So if we look at the IRS code and how a qualified educational loan is defined, again, we get really technical here, so I apologize, but there's no other way to do this. Qualified higher education expenses means the cost of attendance at an eligible educational institution for the purposes of the preceding sentence, eligible education institution has the same meaning given under the term by 26, and it goes to a different section of a different statute. At the end of the day, it means an institution that receives federal funds, or a Title IV school. So, okay, So that's something interesting. So if it's a private student loan that is given at a school that is not, that's not a Title IV school and does not receive federal funds, that's a debt that could be dischargeable. So an example of this would be like a medical school in, in a foreign country or something like that. That could be a dischargeable debt. And then also we want to look at cost of attendance, because if the private loan exceeds the cost of attendance, then it is dischargeable. And there is a way to determine the cost of attendance for a school. And I included as Exhibit 1 in my materials, there's a website where you can go and you can look up the school and see the cost of attendance. Okay, so let's see what we can do here. So the first step is I looked at our ITT Tech and Lawrence Tech Title IV schools. So I was able to look at the school codes list, and the website is again in the materials. And Lawrence Tech is a Title IV school, meaning that it receives federal funds. No real question about that. ITT Tech was kind of interesting because it did lose federal funding in 2014. But at the time Eric attended it, it was in fact a Title IV school. So, okay, so, I didn't really quite know what to do about that, but that was just something I kept sort of in the back of my mind. So the next thing I wanted to know was, well, did those private loans exceed the cost of attendance? Well, I went back to the website, looked at how much it cost, and the short answer was no, it did not. The private loans that he received did not exceed the cost of attendance for either institution. Okay, so far I'm kind of striking out in my analysis because
Carissa, can I ask a question?
Yes.
So, and maybe this is evident, but so you're able to look at the cost of attendance historically?
Yes.
For the period of time that Eric attended.
Exactly, and that's a good point, Kara, because you have to kind of do, it will show by year, so you need to find the relevant year when that person attended.
Thank you.
That's a very good question. And this is, to go back to the first point I made, make sure you're getting paid for this, because as you can imagine, just by looking at this takes a lot of time. Okay, this is very time intensive and this is not easy. And this is something that requires a very intensive analysis if you're going down this rabbit hole. So this is somebody who, you're going to be doing this for somebody who has a ton of debt and is willing to pay you for the time it takes to go through all this, because it's very time intensive. Okay, so and as an aside, if you think you have a good qualified higher education argument that it is dischargeable, you do not have to file necessarily an adversary proceeding for that. If you believe that this is a debt that is excluded because it's not a qualified higher education, or it doesn't qualify, it falls under that exception, then the way that it is often litigated is by a discharge violation. So if they come after the fact and they try to collect on this debt, you can try to file an adversary proceeding as related to the discharge violation. And then the creditor actually bears the burden of proof there. It has to show that the debt is of the type accepted from discharge under 523A8. So I didn't get anywhere with that. So next step is, the good old fashioned Bruner test. Okay, so the Sixth Circuit of Court of Appeals does apply the Bruner test. And here we're looking at undue hardship. And so the elements that we're looking at is that the debtor cannot maintain, based on current income and expenses, a minimal standard of living. 2, that additional circumstances exist indicating the state of affairs is likely to persist for a significant portion of the repayment period, and that the debtor has made a good effort to repay the loans. And of course, the debtor has the burden of proof here. So I felt that under the facts of this case, I had a cognizable argument as to why the debtor met the elements of the Bruner test. And the debtor in this case had made a very good faith effort to repay the loans. And I felt that the debtor could not really pay these off and establish a minimal standard of living, and that this state of affairs was likely to persist. The debtor had children at home. The wife was not going to be able to, work. The household income was going to be remaining more or less stagnant for the foreseeable future. So, we filed the Chapter 7. We filed an adversary proceeding only on the private loans because, as we discussed earlier, the federal loans were resolved already. So we only filed it on the private loans and made an argument of undue hardship. So I'm going to stop my screen share here. Hold on. Okay, so this was ultimately resolved by settlement, and this was a case where we went back and forth for about a year. There was counsel outside of Pennsylvania involved, but long story short in all this, the argument was strong enough that the ultimate settlement was that the vast majority, a very large amount of the debtor's private student loan debt was forgiven. Well, not forgiven. The debtor had to pay a very small portion of it, and at only 1% interest over 30 years. And the payment on that was something like $200 and some a month. And at the end of that term, the rest is essentially forgiven by Navient. So it was an excellent, excellent, excellent result for that debtor. But I thought we had a good set of facts. And the important thing to remember here too is that I do think that with the advent of many people who are trying to push the envelope on Brunner, there's case law that's emerging all around the country. And I think if you can mount a strong argument as to why it should apply here, my experience is that quite often the private student loan creditors aren't necessarily going to want to litigate that because they don't want bad case law. And so they're very motivated to settle it. So I do think, yeah.
If I may ask a question, so how far in the process did you get? Did you, had discovery been conducted? Had you had hearings? I mean, or was it just simply adjourning and continuing to negotiate?
So we completed discovery, and that is an important aspect of it because they did want discovery before they even talked about settlement. And I think that the reason that they wanted discovery is I think that they wanted to see that, I think a Chapter 7, what was in the Chapter 7 petition schedules is really a snapshot, I think, of what a situation was. And I think they wanted many years of tax returns. There was lots that they wanted there. And so we did complete discovery, and they wanted that completed before they even ventured to approach talking settlement. Once discovery was completed, that's when the settlement talks started, back and forth. And so I had a due date for our motion for summary disposition. Due dates were on the calendar, and those eventually were adjourned out, and we were able to settle it. It did take close to a year to settle it. So, but discovery was completed. That's as far as the litigation got. And then we were, and it became apparent pretty early on that we were on a road to being able to settle it successfully. So it just took a while to do the back and forth.
Sure. And we have a question, and I can't give it a name. It's just a Galaxy Note 10. What was the $234 a month for 30 years?
That was his private student loan payment.
And that was 1% interest, correct?
1%. And then at the end, the rest was essentially, it was discharged.
So essentially, like a consent judgment that one would enter into with Michigan UIA, where that stays on the books until you get to the end.
Right. Yep, exactly right. And you know, there was obviously lots of other provisions in there too, where we had, you know, what a default looks like and if he has time to cure it and what, you know, so all those things were negotiated. And so, but that was eventually what it looked like. And for him, that was something that he was very able and happy to work with. And that was something that ultimately he felt that he was, he could live with and fulfill that obligation. And he was also a very reasonable client, which I think is important too, in having reasonable expectations in all of this. Because he knew the downsides to his case was that he was young and he was healthy and he was going to be able to work. He was not a quadriplegic, or, you know, the reality was he knew that. And he was also a person who felt like he should pay something back on his student loans. And he said, you know, it's not that I don't feel like I should pay anything. I feel like I should pay something. And so for him, you know, and this was sort of a meeting of the minds we had before we started this process, was expectations and what he could expect from this process and what we agreed on what a good result was. And so, you know, that's an important aspect of it as well, is to make sure that that discussion is had right from the outset, so that everybody knows what this can look like. And this was right from the beginning, you know, trial. I mean, do we want to go to trial? Not really. I mean, we really don't want to take it to trial. I mean, sometimes you have to, and that's, you know, maybe makes the most sense. But that was not something that we were hoping to come to a settlement he could live with. That's what he wanted. So, you know, it was a good set of facts. I felt like it was not an ideal set of facts, because normally whenever I talk to most people is they think, well, you know, if the person is not, like I said, has this complete hopelessness of a situation, then don't bother. And I don't think that's true either. I don't think you have to meet that hopelessness of a situation to give these things a try.
Fair enough. Now, we do have a question from Marcia. I think it's Mioli. I'm sorry, Marcia, if I said that incorrectly. But she asks, how do you usually get paid for one of these?
I know, such a good question. Okay. So I will say, like, I'm not, you know, I'll tell you how I got paid on this one. Okay. And I've gotten paid on some similar to these, is I get paid to do that analysis, that first step, right? Because to me, and I sort of estimated how long it's going to take me to do the initial analysis of, let's figure out what's going on here, what the status of all these loans are. And so I charge an initial for that, just based on how many hours I think that's going to take me. And then a sit down with them to walk them through, okay, this is an analysis of your situation. This is what I recommend on your next steps. Depending on what those next steps are, okay, if it involves a Chapter 7 and an adversary proceeding, again, some rough estimates of what that's going to take me hourly wise. And again, I sort of put in a handicap for, okay, I've never done this before. So, you know, I'm not going to charge, you know, so I sort of adjust for that, my inexperience on doing something like this. And then I charge them for that. And then this is what it's going to cost. The adversary proceeding, he paid me for that post-petition. So he paid me for the Chapter 7 pre-petition, and he paid me for the adversary proceeding post-petition. And that's how we worked it out. So, you know, in this case, I was really awesome when this happens in the consumer bankruptcy practitioner's world. I was compensated for all the time I put into this case. That's always really fun. And something that makes us all happy. So, and again, it was a great case because at the end of the day, he was beyond the moon thrilled, and he felt like he had gotten his life back. I mean, rather than staring down the barrel of 30 years of making, you know, almost $2,000 a month in student loan payments, he was looking at several $100s a month, $400 or $500 a month total, and that was something he felt like he could live with, and he was very happy. So it was a good result, and I got paid. So that was awesome too. So it was a win-win. So I think we are also now out of time. And by the way, I am happy to talk to anybody that wants to talk about this. My email address and my phone number, you can reach me. Like Kara, I'm also a big nerd. I'm sure you probably already figured that out. Happy to talk about anything and bounce ideas off of other people. And again, thank you for the Debtors Bar for inviting us. This was really fun. And thanks so much, Ryan.
Thank you, guys. That was fantastic, and I'm sure other people would be saying that too if they could talk. All right, so that's the end of day 2. Thank you, everybody, for attending. I believe Fortz wanted to say a word here at the end, but I'm not. There we go.
Hello, everyone. So I know that it's been a long day, and I don't want to take up too much of your time. But on behalf of everyone here at Fortz Legal, I do want to say thank you for allowing us to the opportunity to host this seminar. And obviously we're in a unique environment right now to where we have to pretty much do everything by Zoom and remotely. And so to that point, I do want to play just a short video for you. And I promise we won't be very long.
At Fortz Legal, we know it can be difficult to navigate depositions in a remote setting.
Can you see the exhibit now?
And like it or not, it's here to stay. That's why we crafted a unique exhibit workflow to make your remote deposition experience as seamless as possible.
Hello, how are you today?
Through our system, clients send us their exhibit files. We create an exhibit index and staff an exhibit technician to execute the workflow.
Hi, I'll be your exhibit technician today.
Part of the role of this technician is to display the requested exhibit through Zoom's share screen. Then they provide real-time courtesy copies to all participants by sending secure share links through the Zoom chat. You can schedule your short demo now to experience our exhibit workflow for yourself. We make the remote deposition process easy, and we're here to support you every step of the way.
So basically, with the way that everything's been going on in the world, it is.
Hello, litigators. I'm Jerry Keller.
It is it can be difficult. I know your job is difficult enough to have to navigate what you normally do. Having to take on the technical aspect of it at the same time can be a little bit overwhelming. We've been doing meetings, arbitrations, mediation, bench trials. So what we've been doing this whole entire time is we're recording this seminar. We're going to send out a link to the video to everybody. Also a link within that will be a link to our calendar if you want to schedule a one-on-one demo of how we handle the exhibit workflow and how we can help you with all the technology moving forward. You can do that. So again, thank you. And we don't want to take up too much more of your time, but so that's what we have for you.
Thanks, Eric. So yeah, that concludes the Debtors Bar seminar. Thank you again, all the speakers. Everyone did a fantastic job. Thank you for the attendees. Again, thank you, Fortz. If anybody needs any of the materials, feel free to contact me at the debtorsbarseminar@gmail.com address, and I can get those out to you. Thanks, and enjoy the rest of your day.